In this video, I'm going to explain how to obtain power of attorney in Washington state. I'll cover the different types of power of attorneys, the essential requirements, and the benefits of using statutory forms. So by the end of this video, you'll be able to confidently create your very own power of attorney in Washington state. And by the way, if you feel like you need help creating power of attorney, I recommend contacting people from laudepot.com because they are professionals and they will be able to help you. I'm going to leave a link to their website down in the description of this video. And with that in mind, let's jump right into it. Understanding power of attorney. What is a power of attorney? A power of attorney is a legal document that empowers a trusted individual to handle certain aspects of your financial affairs when you cannot do it yourself. These financial matters may include depositing checks, filing taxes, or making decisions about your real estate property. Types of power of attorneys in Washington state. Washington recognizes several types of power of attorneys, with the most common ones in estate planning being financial power of attorney. This type allows someone to manage your financial and business matters. And power of attorney for healthcare. It grants someone the authority to make medical decisions on your behalf. Both of these power of attorneys are typically durable, meaning they remain effective even if you become incapacitated, making them vital for unforeseen circumstances. Legal requirements for financial power of attorney in Washington. To create a valid financial power of attorney in Washington, certain legal requirements must be met. Mental capacity for creating a power of attorney. The individual creating the power of attorney must have the mental capacity to do so. While the exact criteria for mental capacity may vary, generally, individuals creating power of attorney should be able to understand their actions. If you have doubts about meeting this requirement, consulting an estate planning attorney is advisable. Witnessing and notarizing requirements. In Washington, you must sign the power of attorney in the presence of either one notary public or two witnesses. Although you have a choice, it is best to at least have your power of attorney notarized, as many financial institutions require notarization before allowing your agent to act under the power of attorney. If your agent needs to conduct real estate transactions, your county's land records office will likely require a notarized document as well. If you choose to go the witnessing route, your witnesses cannot be named as agents in your power of attorney. Your home care providers or long-term care facility providers related to you or your named agents by blood, marriage, or domestic partnership. These restrictions are in place to prevent conflicts of interest. Steps to obtain a financial power of attorney in Washington. Here's a simple guide to creating a durable financial power of attorney that is valid in Washington. Step number 1. Create the power of attorney using software or an attorney. Numerous private companies offer forms or templates that you can use to create your power of attorney. For a friendly user experience, consider using laudepot.com, which guides you through creating a valid state-specific POA and estate plan. Alternatively, consult a Washington attorney to create a power of attorney, especially if you intend to include it as part of a comprehensive estate plan. Regardless of your chosen method, the power of attorney creation process typically involves granting your agent specific powers. You can select these powers from a list, such as those related to real estate transactions, banking, financial transactions, retirement plans, securities transactions, business operations, government benefits, tax matters, personal and family maintenance, and more. To ensure that your power of attorney is durable in Washington, remaining effective after your incapacitation, the document must explicitly state so. Washington's power of attorney statute suggests wording such as, "This power of attorney shall not be affected by disability of the principal," or similar. Step 2. Sign the power of attorney in the presence of a notary public or two witnesses. As mentioned earlier, you should notarize your power of attorney in Washington. While the state also allows for two witnesses, it is generally advisable at the very least to have your power of attorney notarized. Step 3. Store the original power of attorney in a safe place. Once the power of attorney is completed, store the original in a secure location that your loved ones can easily access. Ensure they know where to find it, as your attorney in fact may need the original in case you become incapacitated. Step 4. Give a copy to your agent or attorney in fact. Provide a copy of the power of attorney to your appointed agent, ensuring they are familiar with its contents. Step 5. File a copy with the recorder's office. If you have granted your agent the authority to conduct real estate property transactions, file a copy of your power of attorney in the land records office, referred to as the recorder's office, in the county where you own real estate. This allows the recorder's office to recognize your agent's authority if they need to sell, mortgage, or transfer real estate on your behalf. Step 6. Consider giving a copy to financial institutions. Share copies of your durable financial power of attorney with banks and other institutions where your agent might need to carry out transactions. This step can streamline the process, as some banks have specific requirements for accepting power of attorneys. Naming an agent or attorney in fact in Washington. From a legal perspective, you can name any competent adult as your agent. However, practical considerations such as trustworthiness and geographical proximity should influence your choice. Washington allows you to appoint co-agents who can act simultaneously, but it is generally advisable to have a single agent to minimize potential conflicts. Nevertheless, designating a successor agent, an alternate who assumes the role of your primary agent, is unavailable, is always a prudent move as it establishes a backup plan. When does my durable financial power of attorney take effect? By default, your financial power of attorney in Washington takes effect immediately upon creation, unless you specify otherwise. While you can set conditions that must be met for activation, this springing power of attorney is typically not recommended due to its potential complexities. When does my financial power of attorney end? Several scenarios can lead to the termination of your financial power of attorney. Revocation. You can revoke the power of attorney at any time, provided you are mentally competent. No available agents. If there is no agent or successor agent available to act on your behalf. Court invalidation. Although rare, a court may invalidate your document if it determines you lacked mental capacity when signing, or that you were a victim of fraud or undue influence. Additionally, in Washington, if your spouse is named as your agent in your power of attorney, that designation automatically ends if you or your spouse files for divorce. To clarify, your ex-spouse's authority as your agent ends, but the power of attorney remains valid. If you designated a successor agent, that individual would assume the role. And don't forget that if you would like to get help creating power of attorney, I recommend contacting people from lawdepot.com because they are professionals and they will be able to help you. I'll leave a link to their website down in the description of this video. I hope this video was helpful. Thank you so much for watching. Subscribe.